Hearing the appeal, GibFibre Ltd against Gibraltar Regulatory Authority.
I see we've got Sir Peter now. That's fine. Thank you. Yes, Sir Peter, I'm glad to see you've joined us.
Good morning, my lords. Thank you very much indeed.
Are you able to hear me all right?
I am indeed, sir. Thank you.
Excellent. We can hear you perfectly. Thank you.
Are your lordships ready for me to start?
Yes, we are. Thank you.
All right. My lords, well, thank you very much. I think the representation is as per the form circulated by the board. I appear with my learned friend Mr. Allen in case the board is interested or concerned or would like to approve it. There is also in the room here with me my learned friend Mr. Philip Dumas, who's not formally on the record, but as appearing, but is in attendance, if your lordships are content with that.
Yes.
And my learned friend Mr. Segan and George Molyneux for the respondent, and Mr. Palmer and Mr. Moshe Levy for the intervener. My lords, first of all, can I express my personal gratitude to your lordships for allowing me to appear remotely in circumstances which your lordships are aware of. There is a comment, my lords, that has been made by the respondent, to which I do not criticize, but I think deserves a response. And that is that in his written case, the respondent expresses surprise that the GRA should now be appealing against the finding that it had a power to address what it had identified as an anti-competitive behavior. Of course, it is most unusual for regulators to want to turn down powers. Most regulators want more, not less power. But the GRA has, I think, is common ground, always had an instinctive sympathy to the respondent's wish to deliver services into the data center, but has concluded that it cannot help it to acquire the particular form of access and in the way that it wishes to acquire it, which is what we call in the papers the access requested, and that it lacked the powers to do so. So the GRA believes, with respect to it, that the Court of Appeal got that wrong, so we're now, the GRA now, was in the position of having to decide whether to simply move on and exercise powers that the Court of Appeal had adjudicated it had, even though the GRA did not believe it had. The courts established the law, not the citizen. And risk and make a decision and risk it being appealed by the intervener, who would have been, depending on what that decision was, the object of it, and start a challenge, a legal challenge all over again, or alternatively, simply proceed with this litigation and have the matter definitively resolved in this case, which is what it ultimately decided to do. So with that...
If I could make an observation, Sir Peter.
Yes, sir.
What we have in front of us is an appeal against a decision taken back in 2017.
Yes.
And so I presume that it's common ground that we have to decide whether that decision was correct in 2017.
My Lord, I am about to move on to speak in the context of the effects of the European Withdrawal Act, but in that context, which does not address the point that your Lordship has just raised, but in that context, I need to address that point because of the nature of the Court of Appeal's decision and what it was and what it wasn't. And what would the effect be if, for example, if your Lordship decided that as the law was then, the GRA had the power, but as the law is now, it doesn't, that would leave us in a very difficult position because the power has not been exercised. This is not an appeal about a decision which has affected the rights of the citizen, in this case the respondent, as at a particular date in the past. This court cannot therefore place the respondent in the position that it would have been in 2017 had the GRA not made a mistake, if that is what your lordship's find.
But no, the only point I had in mind, Sir Peter, is that insofar as there have been any changes in the law since 2017, which might affect the powers of the GRA, I don't think we're being asked to decide this case on the basis of the current law.
No, well, my view is, I don't know to what extent this is shared, that there is no relevant change in the law, and that the point to that extent is academic.
Yeah,
but
that may well be.
But were that not the case, my lord, the difficulty would be that even if your lordship decide that in 2017 the law of Gibraltar was ABC, but that it is no longer ABC, it's difficult to see how the regulator could now exercise a power which it no longer has under the law as it now is, simply because it would have had the power had it tried to exercise it correctly 3 years ago. The regulator can only exercise now powers that it has now at the time that it exercises them.
Yes.
That would be my submission.
Yes. Yes.
Because it's not the usual case of a power exercised at the expense of somebody. It's a case of a power not exercised.
Yes. While we're having this preliminary discussion, as it were, before you embark on the substance of your submissions, can I just mention one other matter, which it may be you would prefer to leave to the other parties, but reading the parties' written cases and interveners' written case as well, the board has been left without any real sense of what is the commercial reality lying behind this dispute. Why does the access sought matter so much to the parties?
I'm very happy to address that from the regulator's perspective.
Well, that would be helpful.
That.
Yes, that would be helpful.
Indeed, my lord. Well, I'll do that now then, perhaps, my lord, because it allows your lordships to sort of get going, so to speak, with that thought in your minds. It's obviously one that has occurred to your lordships already. So, my lord, the point is this: leaving to one side the question of whether there are any terms under the law under which this access could be ordered, the commercial importance to it is this: that Gibraltar, the commercial importance as the regulator understands it and is sympathetic to of the respondent, is that Gibraltar is a jurisdiction that your lordships may know has established a significant presence in several industries that are quite computer intensive and operate on the basis of servers. One and foremost is the online gaming industry, but also to some extent the financial services industry. And it is the standard practice of such organizations to place their servers not in their own premises but in data centers. And that is because servers require very careful environmental conditions. They require a huge amount of power, they require climate-controlled rooms, they require very considerable levels of security, and therefore the industry practice establishes that specialist organizations, which we call data centers, are established to provide such facilities. Now, if you locate your server, if you're a gaming company, and you locate your server in, let's say, Rocolo's, Gibtel's subsidiaries, data center, and Gibtel, through its control of Rocolo, Gibtel itself being a telecom operator providing telecom services to those servers, who have located their servers in their data center. If GibTelecom then does not allow a competing telecom operator to access the data center, then those clients that have located their servers in the data center are forever, I say forever, I'll qualify that in a moment, are forever inaccessible to, in this case, the respondent, as potential clients. I qualified the forever because, of course, it's subject to the caveat that these server owners, these gaming companies or whatever they are, could relocate their server away from the intervener's data center to some other data center in Gibraltar, which would give them access because it wasn't owned by a rival telecoms provider. And there are such cases. So that is, in a sense, the commercial importance of it. And that is the reason why the regulator has from the outset been sympathetic and tried to help until it stumbled upon what it believed, on legal advice, was a legal impediment to doing so. I don't know if that is at all helpful, whether your lordship would like more detail.
No, that's very helpful. And just to avoid any possible ambiguity, by gaming we're talking about gambling, not computer games.
You could be talking, you're talking gambling, but you could be gambling of both kinds. That is to say, betting and gaming, casino gaming.
Yes, I see.
The gambling industry is divided into those two broad categories. What you would do in a casino and what you would do at a bookmaker's, in short.
Yeah. Thank you very much.
Well, my lord, with that introduction, welcome to the esoteric world of telecommunications regulations. It's not, as your lordship will find, not an easy area. Some of the concepts are difficult to grapple with. My lord, there was an issue which I put into my written case only because I felt an obligation to the court, not because I thought it may be relevant or because I was inviting the court to depart from any European case, but only because, as the senior Gibraltar-based counsel, I thought it duty-bound to just let the court know, in the context of Brexit, what Gibraltar's withdrawal infrastructure looks like in terms of its effect on our statutes and previous EU obligations and things of that sort. So I've set out what our law, what the Gibraltar Withdrawal Act provides, not because I think that your law, I'm going to invite your lordships to exercise their power to depart from any ruling. That said, if your lordships had other ideas, I would have to address your lordship further on it, because I cannot agree with my learned friend Mr. Segan's interpretation, for the reasons that I explained in answer to your lordship's first question this morning. I cannot agree with Mr. Segan that the effect of the, and for the reasons that I explained earlier, the effects of the Withdrawal Act is that your lordships have to look now only at the law as what it was back in 2017 on the date of the impugned decision, and therefore cannot exercise their rights to depart. Not that I have any reason to suppose that your lordship may want to do so, but if they did, I would have to address your lordships further on that. And I was just wondering whether your lordship might guide me, whether I should just leave that to do in case your lordship asked me to, rather than take time now to do it hypothetically.
Well, as far as I can see, neither, and I'll be corrected if I'm mistaken, neither the respondent nor the intervener is asking us to take anything from Brexit other than our inability to refer this case to the Court of Justice. So that, as far as I can see, that's the only difference that withdrawal from the EU has made that has a bearing on the case. I see, I think Mr. Segan agreeing. Is that also your position, Mr. Palmer?
Mr. Palmer.
Oh, I beg your pardon. Mr. Palmer agreeing. Mr. Segan.
Yes, our position is as set out in the written text. We say this is the the issue about the lawfulness.
My Lord, I do not hear Mr. Segan. It doesn't matter now, but it may later.
Right. Was your microphone switched on before, Mr. Segan?
I've understood them both to be
yes,
on.
be on.
Can Sir Peter...
You're hearing now. That's
sounds
good.
though it's my fault. Apologies.
Yes.
Let me repeat that for Sir Peter's benefit. Our position is as set out in the written case, i.e. this is a case about the lawfulness of a decision taken in February 2017 and therefore has to be resolved by reference to the law as it stood in February 2017. I think it's right to say that at various points all the parties refer to the later directive by way of, as it were, comparison.
Yes.
But on the question what law falls to be applied, we say it's the law in 2017.
Yes, yes.
But the Court of Appeal did make an order that the decision be reconsidered in accordance with the principles in its judgment.
Well,
if those aren't the principles, then that wouldn't be a correct decision.
Well, your Lordship is obviously right that if it goes back on a remittal, and to this extent I agree with Sir Peter, obviously the point will at that point have to be resolved in accordance with the law as it currently stands.
Yes, yes. Yes, that's very helpful. Thank you, Mr. Segan.
Okay.
So, I hope that's clear, Sir Peter.
Yes, and only to add to that, my Lord, that would be regrettable because then the GRA would not obtain the clarity that it has appealed to seek and obtain. My Lords, may I proceed? I must say I'm having
I'm so sorry,
Mr. microphone, but I'll press on.
I think, Mr. Peter, Lord Sales has a question to put to you.
Thank you, sir.
I don't know if I need to prep. Can you hear me, Sir Peter?
I can, thank you, my Lord.
Your last comment just mystified me a little bit. I thought, before you said what you said, that we'd reached a point that everyone was agreed that we focused just on the law as it was at 2017. But your last comment seemed to suggest that that wouldn't achieve the clarity that the GRA in fact desires.
If anyone were to argue that the law had changed, if no one argues that the law has changed, then we get the complete clarity. But if the law has changed, and your Lordships make a decision on it as it was before it changed, we will get a ruling which will be will not be able to inform the GRA's view as to what its current powers are, because your Lordships will not have expressed a view on the effects of the change to the law on the access requested. I'm not aware that anyone is actually arguing that the law has changed in any relevant sense. It has changed, but not in any relevant sense.
They're not, I agree, but that's because, as I understand it, that's not an issue for us. In a sense, we're not going to decide whether the law has changed or not, because no one has presented detailed argument to us about that. So isn't the position that we simply decide by reference to the law in 2017 and leave it, the GRA, if you like, at risk to some degree that someone comes up later to suggest that there has been a change in the law, but at least you'll be so much the further forward in that you know what the original platform was, and it may be that the current state of the law can be assessed in the light of what we say.
I accept, my Lord, that must be the correct position, yes.
All right.
I don't think we have, as far as I've noticed anyway, we don't seem to have in our bundles the provision under which this appeal is brought, which is, I think, Section 91 of the Communications Act of 2006. But that provision presumably defines the scope of and the nature of an appeal.
Correct, my Lord. In terms of, from memory, I think it says any measure adopted by the GRA with which a party is aggrieved.
Mm-hmm. Yeah, I see. And I don't know if there's a provision which stipulates the grounds of appeal, but I presume they would include error of law.
Oh yes, for sure, my Lord, yes.
An relevant error would obviously be an error which affected the decision at the time it was taken.
Correct. It would be ahead of today if your Lordships rule against me.
Yes, yes, thank you. Well, I think with those preliminaries out of the way, we're probably in a position now to proceed to the body of your submissions.
Okay. Well, I won't take your Lordship's time unless your Lordships indicate otherwise as to how the appeal has got to this and what the first appeal court decided and what the second appeal court decided, unless your Lordships indicated. Suffice it to say that the issue boils down now for your Lordships to decide whether the Court of Appeal erred, and if so, to what extent, in deciding, effectively, having decided that Article 12 did not avail the respondent because he wasn't seeking access to GIB Telecom's network or associated facility, whether they were nevertheless right or wrong to decide that the GRA did have the power to grant the access requested under Article 5. And then there is this third ground, which I think my learned friend Mr. Segan is going to try and persuade your Lordships should not express a view on whether Market 4 applies. That may, depending on the view that your Lordship takes on my principal submissions, that may achieve some significance, because on it turns the question of whether GIB Telecom had or had not got SMP, significant market power, in a relevant market that's relevant to the access requested. So the GRA's position is that it did not have, because market 4, in which it did have SMP, is not a market engaged by the access requested, and therefore for the purposes of this decision and this matter, it has treated GibTel as a non-SMP party. The Court of Appeal and my learned friend Mr. Segan and his clients contend, to the contrary, that Market 4 is engaged, but it's irrelevant because Article 5 doesn't turn on whether you've got SMP or not. And my submissions, particularly on ground 1, go straight to the heart of that question. Is it true that on its proper interpretation, Article 5 does not turn, and to what extent, if it does not turn, on whether the requested party has significant market power? So depending on what your Lordships decide on that question, it may be significant to decide whether Market 4 bites or doesn't bite on the access requested. So on that basis, my Lord, in short, my ground 1 will speak to whether the access requested is outside the scope of Article 5. My ground 2 will speak to whether it's outside of the scope of the entire directive. And that is not a distinction without a difference, as I'm sure your Lordships will immediately observe, because if ground 2 succeeds, then ground 1 must. So if it's outside the scope of the directive, it must necessarily be outside of the scope of 5. But the reverse is not true. A success on ground 1, if I persuade your Lordships that it's outside of the scope of Article 5, that does not necessarily, depending on the reasons that your Lordship come to that conclusion on, if they do, that does not necessarily mean that it's outside of the scope of the entire directive. With that, my Lord, I'll go straight to a 2-minute explanation of the basis of the common regulatory framework, which is, your Lordships may know even before reading the papers of this case, is basically one that seeks to balance competition, the whole European Union regulatory harmonization in this area. It was to separate historical nationally owned monopolies from their monopoly and their ability to keep other people out. That was to be balanced with allowing investors in infrastructure to derive a fair return from their infrastructure. And for that purpose, that balance is struck by what is called in the papers and in the law the SMP procedure. The community, the European Union, identifies markets which it thinks are uncompetitive across the Union. National regulators see whether those markets in their countries are uncompetitive. If they are, they identify individual one or more operators within it that exercise dominance in that market, and if they come to the conclusion that they do, they must impose at least one of the conditions set out in Articles 9 to 13 of the Access Directive. Of those 9 to 13, we are concerned with 12, Article 12, because that is the one that deals with access and interconnection to networks and associated facilities, but the others deal with 13, for example, deals with numbers and access to numbers and things of that sort. Another one deals with transparency and accounting. We're not concerned with those, but the panoply is wider than just 12, but we will focus on 12. That is the regime, and that is the context, and that is the balance to be struck. So the balance is between the regulatory objective of competition on the one hand, and the SMP procedure and the reason why it was created on the other. I won't take your Lordship's time with any detail about what the SMP procedure is. Suffice it to say, it's a long and complicated process that involves much public consultation and much assessment, which ends up in a decision notice, in a notice by the regulator saying, I've examined the market, I think it's uncompetitive, and within it I have identified A, B, C operators who exercise dominance in that market, and therefore I impose on those operators the following measures under 9 to 13. If your Lordship wanted to see how that works in more detail, at paragraph 9 of my skeleton argument, there are several places, not least by the House of Lords in the BT and Telefonica case, in which your Lordships could obtain a sketch outline of just how that works in the practice and in the detail. So my main submissions, my Lord, to which I will now move, will require, and I will take your Lordships through a detailed assessment of what the GRA considers is the proper interpretation of Articles 4, 5, 8, and 12 of the Access Directive. And so that is during my address, that is the document that your Lordships will most frequently be turning to. Just to say finally, before I get cracking, that GibTel has SMP obligations in Market 4, so there's no question about that. The question is whether Market 4 is engaged, not whether it has SMP in it. It does. So, my Lords, if I could then now, and I won't unless your Lordships indicate otherwise, say anything more about the changes of the law. Your Lordships know, paragraph 15.1 of my written case, that something called the European Electronic Code, EECC for short, has effectively consolidated, and in the process of consolidating, introduced quite a lot of both detailed and conceptual changes to the common regulatory framework, but happily for us, I think we're all agreed, not any that complicates this hearing. I would, however, my Lord, with your Lordship's indulgence and my learned friend's patience, like to withdraw one or two of the remarks that I make. For example, in paragraph 15.3, I say that the wording of Article 61 of the EECC supports my case. In other words, I make a remark that suggests that it positively and in terms, I'd like to, with your Lordship's permission, resile from that remark and simply abandon it for the purposes of this case.
Forgive me, which is the remark in 15.3?
In paragraph 15.3, and it's replicated later on, I say, and the article in the EEC that recasts Article 5 which is Article 61 in the ECC. So the equivalent of Article 5 in the ECC is Article 61, and I say sustains the GRA's case as to the correct meaning and effect of Article 5 of the Access Directive. In other words, I was borrowing how the European Union had formulated had wordsmithed the new Article 61 to try and demonstrate that my interpretation of Article 5 is correct. It doesn't do me harm, but I acknowledge it doesn't do me good. It doesn't help me. It doesn't help me or unhelp me. It's just completely irrelevant. My comment was simply wrong.
Thank you.
And was based on poor punctuation in Article 61. But I withdraw the remark, if your lordships will permit me.
Thank you.
So, my lord, the grounds in Article 1, in ground 1, your lordships will be familiar from. The grounds of appeal are at electronic bundle 496. Basically, the difference between the parties is that they say it does and we say it doesn't. By the parties now, I suppose I should include the Court of Appeal. I suppose I should stop referring to the parties. This is an appeal against their lordships' decision below. That Article 5 provides a general freestanding power on an operator with SMP in a relevant market to provide access to things that it could not be ordered to provide access to under Article 12, for which it would need SMP. And also, they say, on an operator without SMP in equal measure. In other words, they say that about this. Now, my lord, that is the decision. So the respondent's case and the court and the basis of the decision of the court below was that Article 5 gives the GRA, and I'll enumerate these, although they're not enumerated in any document, a freestanding general power to impose, 1, on all operators and service providers, i.e. those that have and do not have SMP, for all purposes, in all circumstances, and by all and any means, provided only that it is in pursuit of a regulatory objective under Article 8 of the Framework Directive. We've got to be a bit careful with Article 8, my lord, because there is a frequent reference to the Article 8 in the Access Directive, which is about imposing obligations on SMP people, and Article 8 of the Framework Directive, which is where the regulatory objectives are set out. In this case, we are concerned with the promotion of competition regulatory objective, although there are others. So provided only that it is in pursuit of that or some other regulatory objective, and the requirement in Article 5.2 for objectivity, transparency, proportionality, non-discrimination, and following the required procedure are complied with. So long as the GRA complies with those two provided only that's, it opens the door for them to basically decide what they want against whoever they want for whatever purpose they want, subject only to those two constraints. My lord, that this is the case of the respondents is clear from a number of the paragraphs in their written submissions, which your lordships will find at the electronic bundle. My first references to it will be at electronic bundle 545. So, for example, at paragraph 11, which is at page 545, my learned friend Mr. Segan starts, the power to impose obligations on Article 5.1 is thus expressly tied to the very broad concept of access as defined in Article 2A. And then at paragraph 12.5, which your lordship will find at page 546, paragraph 12.5, he says at the beginning, the obligations set out in Articles 9 to 13 of the Access Directive may also be imposed on an operator under Article 5. And then he goes on with matters that we will come back to, and he finishes by saying, the effect of Article 8 is simply that where the NRA has made a finding of SMP, the NRA must then impose obligations, which obligations could in principle have been imposed under Article 5 in any event. In other words, he is arguing that Article 5 and Article 8 are coextensive as to scope, and the only difference is that under Article 8 it's must, and under Article 5 it's may. And it is of the essence of the GRA's position that that is an untenable distinction which cannot survive proper scrutiny and proper interpretation of these articles. And I beg your pardon, sir.
Am I right in thinking the reference to Article 8 in paragraph 12.5 is Article 8 of the Access Directive?
Yes, my lord.
Yes,
correct.
Rather than the framework. Yes, thank you.
Correct, my lord. My lord, and then at paragraph 22.1, which your lordship will find at page 550 of the bundle, he says, on any ordinary reading, the words of the first sentence of Article 5 confer a general power and indeed obligation. We'll come back to that word, because your lordships can see what my argument is going to be. He cannot argue both may and must, and at the same time argue obligation. It's one or the other. It cannot simultaneously be permissive and mandatory. And indeed obligation on NRAs to ensure adequate access in pursuit of the objectives identified in Article 8. NRA are obliged to exercise. So all I'm doing here, my lord, is just illustrating to your lordships how it is the respondent's case, as indeed it was the basis of the decision by the Court of Appeal, that Article 5 is a general power to do all and everything, whether it's to SMP or non-SMP operators, provided only that it was in pursuit of a regulatory objective, that it was transparent, non-discriminatory, etc., and you followed the correct procedure under Article 5, which is, and we say that that position is not correct. So, my lord, our response is that the relationship between these articles is much more complicated than that, that these articles do not stand on their own. They all form part of a common framework regime both under the Framework Directive and under the Access Directive, and that you cannot just take one freestanding one out of context, particularly when doing so would render complete nonsense not just other provisions of the directive, but other provisions of the directive which are the key measures that underpin the entire essence of the common regulatory framework, such as, for example, the SMP procedure. So, my lord, so our position is that Article 5 power, that the Article 5 power is that wide. Now, my lord, if I have ever made a statement in my skeleton argument, in my written case, my lord, that Article 5 does not provide a power, the first subparagraph, to be distinguished from paragraph 5.2, Article 5, as your lordship will see when I take them to it in a moment, has an unnumbered paragraph, two unnumbered paragraphs, and all the cases and all the authorities have got into the habit of describing that as the first subparagraph and the second subparagraph. The second subparagraph is little a, b, and little b. The first subparagraph is just this ensuring language, which I have said at some point in my written submission does not create any power. And again, I think that goes too wide, that statement. So the GRA accepts that it does create a power, but a much more limited power than my learned friend Mr. Segan contends for and that the court below found, and that it goes nowhere near permitting the access requested. So, my lords, the first point to make is, which I've already hinted at, is that if the proper interpretation of Article 5 was that contended for by the respondent and the court below, it would render completely otiose the very considerable structure created by Articles 8 to 13, and indeed the SMP procedure by which they are to be administered under Article 16 of the Framework Directive, where the SMP procedure is placed, and would rip the heart out of the entire common regulatory framework. Because if Article 5 provided the general power to the GRA that results from that interpretation, it would leave nothing to balance, which is the essence of the whole structure. Obligations which under the procedures in 8 to 12, that can only be imposed on SMP operators under the SMP procedure under Article 16, can be imposed only on operators with SMP under those articles, could nevertheless be imposed on every operator, even if they didn't have SMP, under Article 5 by their interpretation. What is more, not only could be imposed on SMP and non-SMP people alike, an even wider range of access obligations could be imposed and can be imposed on SMP operator under the SMP under Article 12. So Article 12 is restricted to access to network and network facilities. And that's the reason why the Court of Appeal found for the GRA and against the respondent on what we call below the Article 12 point, couldn't have access under that, because it wasn't that. But on their argument, Article 5 lets that and everything else that he says fits into the definition of access as a word in this scheme, and that there is a general power to allow access to all of that. In other words, why would any regulator go to the considerable trouble of complying with the SMP procedure and Articles 8 to 13 and limit themselves to that when they have this omnibus general application, very little procedure, a little bit of consultation only, under which they can do what they like to whoever they like, including SMP people that they would otherwise have to pursue only under Articles 8 to 13. So it would never be necessary to rely on what is called ex ante regulation, because 8 to 16 of Framework Directive and 8 to 13 of Access Directive are in effect the ex ante regulation, whereas this one is the ex post regulation, if you like, power.
So, Peter, when you say
yes,
why would a regulator go to the trouble of going through the SMP procedure, isn't the regulator bound to go through that procedure under Article 16? I thought part of the structure of the Common Regulatory Framework was that regulators were required to make assessments of market power in order to determine whether SMP exists in any particular markets. So,
correct.
Isn't one answer as to why would a regulator go through that process that they're obliged to go through that process? And I wondered whether another point might be that when one looks at the structure of Article 8 of the Access Directive, that imposes, where SMP has been found, particular obligations on national regulators to impose the very precise obligations which they're empowered to do under Articles 9 to 13, which seem to be a different structure of analysis for a regulator to go through, as opposed to what is alleged to be a general power in Article 5.
Precisely so, my lord. The Commission identifies markets. National regulators are bound at least to examine their own national markets in those areas and assess whether they believe it to be uncompetitive as well. In other words, the Commission doesn't decide that a particular market in the UK or Gibraltar is uncompetitive. It identifies a market in this or that, and then the Gibraltar regulator or the UK regulator, Ofcom, decides whether the UK market suffers from that ailment or doesn't. So they've got to do. And if they find that there is non-competitiveness, they have to impose at least one of the obligations under Articles 9 to 13. The very point that the GRA is making here, my lord, is that according to my learned friend and the court below, the GRA could have done all of that regardless of the Commission having identified a market, regardless of it having assessed whether the UK market suffered, the Gibraltar market suffered from that non-competitive, regardless of anybody having been identified as having dominance in it, and without having imposed SMP obligations. All that it could only do, pursuant to that process, according to the Court of Appeal and my learned friend Mr. Segan, can be done under Article 8.5, because they argue it can be done with or without SMP. And all that procedure is only to establish whether there is somebody with SMP in the market. So your lordship is right to say to me and to remind me that, of course, there is the element of compulsion of going through the process, but the process for actually applying specific measures is much simpler under Article 5 than it would be under Article 8. And why would the legislature create a regime that provides for this to be done to subpoena only in certain circumstances under this part of the legislation, but under that part of the legislation, the same thing can be done to subpoena without those conditions being present? It's just not a rational structuring of legislation. And your lordship will see that that is not what the authorities do. I wonder whether your lordship would allow me just to get to the assessment of what we say the correct reading of the articles is, one with the other.
Yes, of course.
I oblige, my lord. So my learned friend attempts to answer your lordship's question by saying 5 is permissive and 8 is mandatory. But of course, that does not provide an answer, as we shall see in a moment when we come to the analysis. But in any case, he has the problem that he doesn't actually argue that Article 5 is permissive. He argues, and indeed the language isn't permissive. The language says that if appropriate, that is to say, if the relevant circumstances, as my learned friend Mr. Segan defines them, are present, then the GRA shall ensure. Shall ensure is not permissive. The only thing that the GRA can decide is whether it's appropriate, and therein lies the key to the correct interpretation of the interrelationship between all these articles, as I will come to in a moment. So, for example, if I could just point your lordships to paragraphs 1 to 8 of my learned friend's written case. So paragraph 1, that your lordships will find at page 540, pointing to section 19(1) of our Communications Act, he says that, quote, the GRA was and remains obliged to take all reasonable measures aimed at promoting competition. That's not the language of may as opposed to must. And at paragraph 10 of his skeleton argument, which is just a few pages later at 545, he says, Article 5 provides, 1, and he cites national regulatory authorities shall, acting in pursuit of the objectives, encourage and where appropriate ensure. And there he's just quoting from Article 5. But that is a sense to which Article 5 on its terms is not permissive. To the extent that it imposes obligations, the exercises of those by the powers that it gives are not optional, they are mandatory. And he says at paragraph 22...
If I may, Sir Peter, the point he
yes.
makes in 12.5 that you took as... he's not saying that there's no obligation in Article 5. He's simply saying that the difference is that the obligations in Articles 9 to 13 are mandatory when you have a finding of SMP and under Article 8. And those obligations are not mandatory under Article 5. That's his point.
But my Lord, I don't think he makes that point, because he's saying that Article 5, he's emphasising, your Lordship has mentioned paragraph 12, I was reading to him from paragraph 10.
Well, you previously read 12.5, which is the nub of his point.
The first paragraph I referred to in his skeleton was paragraph 1, which was taken from section 19(1) of our Communications Act.
Yes.
And that simply says, and he says, as the National Regulatory Authority for Electronic Communications Network, the GRA was and remains obliged to take all reasonable measures. Is your Lordship saying that he thinks he's limiting that to 12, to 8 and 12 rather than 5?
What I'm trying to say, Sir Peter, is that he doesn't suggest that there's no obligation in Article 5. Nowhere that I've seen in his case does he suggest that.
Oh, my Lord, so you don't think he makes the must-may distinction?
He does make a must-may distinction, which he makes in paragraph 12.5, but he's not there, as I read it, suggesting that there's no obligation in Article 5. The point he's making is that you only have an obligation to impose the Article 9 to 13 obligations under 8, and that you do not have such an obligation under 5. It is an obligation under 5, but it's to operate a very general power, not to impose the Articles 9 to 13 obligations.
But, my Lord, the absence of an obligation is either results in permissiveness or you stay in mandatoriness. If he's underlining must when he's talking about Article 8 to contrast it with Article 5, he must be. I mean, if your Lordships are not going to take that insinuation, then I can ignore the point. But he must be insinuating or implying even to your Lordships that is to be contrasted with the alternative regime, which is not must. And if it's not must, it can only be may. I'm sorry, but
it's not must or may in a vacuum. It's the content of the must or may that you have to focus on. And he's talking about the content being the Article 9 to 13 obligations. It's quite a simple point, I think. But
yes, my Lord, except that he
argues. What is wrong with what he says in 12.5?
That he also argues in his written submission that anything that can be done under 8 and 12 can also be done under 5. Right. So it's compulsory under 12, but and permissive under 5. And I'm saying that cannot be so.
Right.
But surely the difference being emphasised in GFS's case is in the structure of the obligations which arise. So when one is has identified going through the SMP procedure that there is SMP, so that Article 8 of the Access Directive is engaged, very focused and specific obligations arise in relation to the national regulator, which we've talked about. That focused and specific form of obligation does not arise under Article 5. A different obligation, it is an obligation, but it's a different obligation, may arise, but depending on a different process of assessment by the regulator as to whether they should intervene or not. Isn't that the difference between the two regimes?
Indeed, my lord, except that the regulatory objective, as relevant in this case, is the same in both. In other words, competition. Competition underpins the framework in 8 to 12 and 16 of the Framework Directive and the whole SMP procedure. And competition is the very same objective that he relies on in 5 to say that we're obliged to exercise our powers under them to order the access. Now, I will come to explain, Your Lordship, the GRA's rationale and argumentation for why Article 5 is not open to that interpretation, regardless of the may-must point. My case does not depend on the may-must distinction.
Yes, thank you.
So, the second effect that their interpretation of the argument has is that it would render nugatory Article 8.3 of the directive, because Article 8.3 says, in short, as we'll come to it in a moment in detail, it says that access obligations other than those in 12 cannot be imposed on an SMP operator without the permission of the European Commission. And that restriction, that provision in Article 8.3 that says that access regulations can only be imposed on SMP operators, either the ones in Article 12, as far as relevant to this appeal, and if the regulator wants to appoint any additional ones, it has to be with the permission of the Commission. This is I will be referring to this as the issue relating to the last paragraph of Article 8.3, and I'll come to that in a moment. Just for your lordships, remember that if Article 5 has the width of meaning that for which my learned friend contends, it would simply circumvent the provisions of the last paragraph of Article 8.3, which I'm not asking your lordship to turn to now, because I will be asking them to do that in just 2 minutes or 3. Would be rendered completely nugatory. It could be circumvented simply by proceeding under Article 5 instead, in respect of procedures, in respect of measures, which Article 8.3 says can only be imposed with the permission of the Commission. Article 5 does not require such.
So, Peter, what do you say then about the opening words of Article 8.3? That the provision you've pointed us to is without prejudice to the provision of Article 5.1.
My Lord, what I think I should do is plough straight into the analysis of these articles, from which our position on all these questions will emerge. Perhaps I spent too long in dancing around that. And if your lordship will allow me to go straight to that analysis, I think your lordship would see why the GRA interprets this provision differently, as indeed have done UK courts and others, differently to the way my learned friend of the Court of Appeal has done so. So, if your lordships could just turn for completeness to Article 4, which...
Sorry to intervene again, but it strikes me as curious that Articles 9 to 13 each begins by saying a national regulatory authority may. None of those articles refers to SMP. They're written in perfectly general terms and on their face confer a discretion.
The answer to that, I beg your pardon, your lordship not finished.
One might, if one were coming to this completely fresh, think that Article 8 was imposing an obligation to take action under those articles where SMP was established,
right,
but that there was otherwise a discretion in any event to take steps under those articles. That
is my learned friend's position, my lord, but not the GRA's, and it's not how others have interpreted this. But I'll come to that, my lord, just now when I take you to Article 8 in some detail. So if your lordships could turn to page 605, your lordship will see this is the beginning of the story of 4, 5, 8, and 12, and the correct interrelationship between them. So, my lords, Article 4 is about the rights and obligations for operators. The distinction to be drawn always is between electronic communications network operators, in other words, companies that own and operate their own networks, and service providers, because your lordships know that your lordships can buy telephone services from people that don't have their own networks. They just then piggyback on somebody else's. They're called service providers. So Article 4 applies only to the rights and obligations of network operators to give each other interconnection. And Poland decided that that was the correct, the Poland case decided that that was the correct interpretation, and somebody who is not an operator but a service provider cannot rely on Article 4 for interconnection. So Article 4 is just about interconnection of networks between operators of networks. And the first part of it says that they shall have a right to do so, because originally it was questioned whether it was illegal. Cartel and things of that is illegal to network. So this decides that it's a right, that it's not illegal to interconnect. And then 4 lines down, it says, and an obligation to do so, an obligation to negotiate with each other. So moving on, that does not concern us except as part of this web of how all these things are to be interpreted in relation to each other. But we are not concerned in this case with a request that involves interconnection. So turning now to Article 5, my lord, your lordships will find that at page 606. Your lordships the first thing your lordships may want to note is the heading of Article 5, which is powers and responsibilities of the national regulatory authorities with regard to access and interconnection. And the first subparagraph, the beginning national regulatory authorities, the second subparagraph begins in particular. The first subparagraph says that acting in pursuit of regulatory objectives, we shall NRAs shall encourage and, where appropriate, ensure, and those are words that are going to loom large in my argumentation, where appropriate, ensure, as will the next words, in accordance with the provisions of this directive. And we'll come in a moment to the effect of the second paragraph. So, and where appropriate, ensure in accordance with the provisions of this directive. Those words have to be given a meaning. And it's the GRA's view that the court's decision and the respondent's position gives them no meaning at all. So, where appropriate, ensure in accordance with the provisions of this directive, natural meaning of those words, several points emerge. First, the reference to this directive. If Article 5 had the freestanding general meaning for which others contend, it would simply have read, national regulatory authorities shall, acting in pursuit of the objectives set out in Article 8, encourage and ensure adequate access and interconnection, i.e., it would have excluded the words, and where appropriate, brackets ensure, in accordance with the provisions of this directive. So the ensuring is only required to take place when it is appropriate in accordance with the terms of this directive. And in accordance with the terms of this directive includes the provisions of Article 4.1 that I've just referred your Lordship to, which is relates to interconnection between network operators, and Article 8.3 and the other parts of Article 8 dealing with the imposition of obligations on SMP operators. So, the general wording of Article 5 is circumscribed by the ensuring only having to be done when it's appropriate and in accordance, and then, if it's appropriate, done in accordance with the provisions of this directive. The respondent now seeks to defeat this analysis by arguing, as he does at paragraph 23.3 of the written case, which your Lordship will find a paragraph at page 552, that the words "in accordance with this directive" mean only this, that reflecting Article 5.2, to which I'll come in a moment, obligations may only be imposed under Article 5.1 if they are objective, transparent, proportionate, and non-discriminatory, and implemented in accordance with the procedural safeguards in Articles 6 and 7A of the, or 2.7A of the directive. But, my lords, with respect to my learned friend, this cannot be right for two reasons. First of all, Article 5.2, which your Lordships will see there on the following page, Article 5.2, not the second subparagraph, Article 5.2 says, and indeed 5.3, say that already obligations and conditions imposed in accordance with paragraph 1 shall be objective, transparent, proportionate, and not discriminatory, and shall be implemented in accordance with the procedure referred to in Article 6, 7, and 7A of the directive. So when 5.1 uses the words "in accordance with the directive," it cannot have meant simply to render redundant what is specifically and in terms provided for in paragraph 5.2. And the second reason why it cannot mean that my lords, is that if Article 5 meant to have said that, it would have said one of two things. It would have said national regulatory authorities shall, acting in pursuit of the objectives thereof, encourage and, where appropriate, ensure in accordance with paragraph 5.2 or in accordance with this article. But it doesn't. It says in accordance with this directive. That is to say, all of the directives, and not just the provisions of paragraph 5.2, which must mean something different to what is otherwise specifically provided by a word that is wider than 5.2 and by words that are already provided for in 5.2 itself.
Can I perhaps interject, Sir Peter?
Of course, Mr.
I happen to have found the answer to my own question, the one I last put to you about relationship between Article, about the discretionary nature of Articles 9 to 13. I see the answer is in Article 8, paragraph 3, which lays down a general rule that the obligations set out in Articles 9 to 13 are only to be imposed on operators with SMP. That's a general rule, but there are three exceptions, one of which concerns Article 5.1 of the Access Directive, and another concerns a number of provisions, including Article 12 of the Framework Directive, which has to do with access to buildings and facilities housed in buildings.
Yes, but and other things as well. So that simply says that the prohibition in 8.3, or rather the requirement in 8.3, that Article 12 access conditions can only be imposed on operators that have SMP in shorthand, is subject to, it's without prejudice to, it's in addition to, nevertheless, anything that can nevertheless be done under 5.1. And therefore that leaves unanswered the question, what can be done under 5.1? And that requires the question to be answered, what is the correct interpretation of 5.1? So, my lords, in terms of what then 5.1 permits,
Peter, could I just ask you about the submission that you're making now about the meaning of in accordance with the provisions of this directive? I think the Court of Appeal's view was that suppose a situation where the SMP process has been gone through and an operator has been identified as having SMP, so that the Article 8 to 13 regime is applicable in relation to them. I think the Court of Appeal said, well, in that situation, one would not apply a general power under Article 5. One would leave the position to be resolved according to the more specific regime in Articles 8 to 13. And I wonder what you say about that, and if it is correct, would that not give some content to the phrase in accordance with the provisions of this directive in Article 5.1, as in effect limiting the circumstances in which the general power in Article 5.1 could be used?
My lord, I say that the phrase in accordance with this directive means the whole of 8, which I'm going to come to analyse in a moment. But just to answer your lordship's specific question, it was going to be my closing words on ground one, but I'll utter them now. What the Court of Appeal finds violates and cannot survive the effect of the last paragraph in Article 8.3, which I would come to in just a few moments, which says, in terms separately to the without prejudice to 5.1, indeed in our legislation it's even transposed in a different subsection which is not subject to the without prejudice imprimatur, which says in terms that you cannot impose access obligations of the sort. You cannot impose on an SMP operator access obligations beyond those that you could impose under Article 12. In other words, that you couldn't impose under Article 12 without the permission of the Commission. Your Lordships will see that in a moment when we go to the last paragraph of Article 8. So therefore the words in the judgment to which your Lordship has just referred me would fly in the face of that. It cannot be that in Article 8.4 the European Union and the national legislatures say, you can apply the following access obligations to SMP operators, but no more than those without the Commission's permission, unless you go under Article 5, in which case you can do it. Because Article 5, it does not benefit from any exclusion from the second paragraph of the last paragraph of Article 8.3. Your Lordship's extraordinary astute questionings appear always to be 5 or 6 minutes ahead of my, which is fine, my Lord. Whether I answer it in my own time or in answer to your Lordship's specific questions is entirely a matter of indifference to me. So, but I will come back to that point. But that is the point, that to do to an SMP operator, this is why I said at the beginning that something might turn on whether I have SMP in a relevant market or not. But to do to an SMP operator under Article 5, what you can't do to it under Article 12, which is the basis of the Court of Appeal's decision to which your Lordship has just alluded, violates the second paragraph of Article 8.4, the last paragraph of Article 8.3. And I will demonstrate, I'll just show your Lordships that in a moment. Can I just say in passing, my Lord, that the list, what is now in Article 5 as A, B, and C in the second subparagraph, that list has grown much longer. Not that it's, I just say it in passing as a matter of interest to your Lordship. That list has now grown much, much, much longer, runs into a couple of pages, I think, in the EECC. It's not just only those three. So what follows now, my Lord, is the GRA's view about why the powers under the second paragraph of Article 5, A, B, and B, can only be imposed on non-SMP operators, and they are the only things that can be imposed on non-SMP operators, subject to the longer list now in the new version of the law. So, my Lord, my learned friend, just to deal with this, relies on the case of recalled support services, which your Lordship will find paragraphs 26 and 29 of that case, which your Lordships will find at pages 1261 and 1262, to say, look, no, in particular means are not the only permitted grounds. And he's right. He's right to that extent. But in fact, this authority is very helpful to the GRA's understanding, if it's correct, of its powers here, because that case is actually authority, and those paragraphs are authority for the proposition, because the High Court judge in paragraph 26 and the Court of Appeal in paragraph 29 of that case made clear that what other factors beyond the in particular ones could be taken into account depended on the other provisions of the directive with which that provision had to be read, and that is precisely the submission that I'm making to you. That the words in particular, properly interpreted in accordance to the recall support services case, do not open the Pandora's box to anything and everything. Rather, what follows them, or what is permitted to follow them, has to be interpreted in accordance with the other provisions of the directive, which is exactly what I'm saying, that is 4, 8, and 12 included. Our position is that and then I suppose I should deal with this point too now, that my learned friend says that the GRA's case is set out in its written submissions must be wrong, and I just flag this point up now so that your lordships bear in mind as I move forward, must be wrong because all the cases that he cites, and I agree that they say what he says they say that Article 5, that NRAs are responsible under Article 5 for ensuring adequate access and interconnection and interoperability of services, quote, by means which are not exhaustively listed there. I shall develop the argument, my lord, by reference to such authority as exists on the point, that my learned friend's submission misunderstands that. The cases, because it does not distinguish between the means by which a purpose is achieved and the purpose itself. What is not exhaustively listed is the means, as the court said in all four cases. The means by which they ensure adequate access and interconnection are not listed, but the purposes for which they can exercise that power are exhaustively listed in Article 5 for reasons that I will explain to your lordship in a moment.
Can I just ask you, in your point about the words in accordance with provisions of the directive, on your interpretation, is the second subparagraph, beginning in particular, one of the provisions of the directive referred to in the first subparagraph? Or is it not more naturally read as an elaboration of the whole of the first subparagraph?
Yes, it's necessarily the whole of the directive, including what follows within Article 5 itself. Except that you've got to, my lord, in our respectful submissions, you've got to read in particular, not just in the context of what recall says, how you interpret what follows the words in particular, but in the context of two other points. First of all, that the words without prejudice to measures that may be taken regarding undertakings with significant market power in accordance with Article 8 appear after the words in particular, and therefore what follows the greater number of words that I've just read out are the only examples that are subject to the without prejudice, as used there in the opening line of the first subparagraph, and that the correct interpretation of the words without prejudice to measures that may be taken under regarding undertakings with significant power effectively is without prejudice to measures that may only be taken. In other words, it's intends to create a list of things that can be imposed on non-SMP operators, notwithstanding that under Article 8, they can only be imposed on operators with SMP. Because otherwise, your lordships would have to, I would have to provide your lordships with an answer to why this section says in particular, if 5.1 means, if the first subparagraph of 5.1 means what my learned friend contends for, what is the need to say without prejudice to measures that may be taken regarding undertakings with significant power in accordance with Article 8? It could simply say, in particular, national regulatory authorities shall be able to impose, if there are only examples of that which can be done. And the issue there, my lord, is that these A, B, and C are measures that can be imposed on SMP operators under Article 8. They fall squarely within the definition of the Article 12 access measures. And the reasons why they're listed here is to make clear that even though they can be imposed under Article 12 on SMP operators, they can be imposed on non-SMP operators, despite the fact that Article 8 says they can't. And that is the relevance of the without prejudice to Article 5.1 in 8.3, and as read with, in particular, without prejudice to measures regarding significant in Article 5. Because otherwise, these words, this is just surplus wordage inserted for no meaning whatsoever. And that is the basis on which the GRA and others, not just the GRA, if I can move on, my lord, and get to them, showing how others have interpreted the interaction and the interplay between these various articles in exactly the same way as I am now submitting to your lordship. So, my lord, my learned junior tells me that I have an hour left. So, with your lordship's indulgence, I'd like to make a little more progress.
An hour and a half, I think, Sir Peter.
Before lunch. No, I see. Okay.
Yes,
very well, Lord, but I have other grounds to and think.
You're halfway through your time.
Thank you, my lord. So, my lord, all the cases, and this can't be any coincidence, all the cases that are cited by my learned friend in this case, and indeed by us, Teliasonara, TDC, Folcomtel, and KPN, they are all cases that fit in little a in the list. None of them said, in none of them did the court say, I can do this because 5(1) is a general power. They all said, I can do this because they are interconnection or end user access cases, which is what A and AB. By the way, my lord, just so that your lordships are aware, AB used to fit in A, and Telesonara is an AB case, which was decided at a time that AB did not exist, under A. AB was introduced, I think, in response to Telesonara, simply to make specific provision for it, the circumstances, but otherwise, A is all about interconnectivity and access through interconnectivity. And your lordships will surely be curious to know why all of these cases use the word solely. So, for example, in your lordships can do it by reference to Telesonara. The court says that the power of the NRA in that case was available under Article 5 solely for the purpose of access to end users. Now, if Article 5's first subparagraph has the broad, general, unqualified, unlimited scope for which my learned friend contends and the Court of Appeal found, what need would the court have found, repeated in all the other cases when citing Telesonara, what need would the court in Telesonara have had in saying solely for the purpose of? It could have done it for that, so, and any other number of purposes, so long as it addresses it's for the purposes of achieving the regulatory objective, and it's done transparently, non-discriminatively, etc., and done in accordance with the procedure in Article 5, which is the effect of the arguments of my learned friend and the court below, there would have been absolutely no need for the court to emphasize that the national regulatory authority had the power to order the access requested in that case, which is of a wholly different nature, solely for the purpose of. Because Article 5, the first bit of it, allows it in for that and any number of other purposes that address the regulatory objectives. And all the cases, the TDC, the drop cable case, those are all cases where the court said it fits within the purpose of little a, and the means are not exhaustively listed there. And we'll come to that in a moment, because in one case it said, and you can have a drop cable, because, by the way, the drop cable case, my lord, is was not an Article 5 case. That's the TDC case. That was not an Article 5. That was an Article 12 case of access to network of associated facilities. But the court said that even there, the means as opposed to the purposes were not closed, and therefore it could extend even to dropping a cable to link to the end users in the context of access to the network. Your Lordships will recall that that is the ground 2 argument, which we will come to in a moment. So these cases and these references to solely for the purpose of interconnection to end users, including the statement that the means are not exhaustively listed there, demonstrate 2 things that I have said this morning. Firstly, that the first paragraph is not as wide as they contend for, because the court would then have had no need for the solely, and secondly, that the courts were in effect saying that they could only do it because of 5 and not under any general power that would be available against all and sundry. My Lord, if I have time, I'll come back to those cases, but I know some of my other learned friends are taking, and I'll come back in my response. I don't want to run out of time to deal with Article 8 and submissions that I need to make in respect of that. So turning, my Lord, to Article 8, which your Lordships will find at page 608 of the bundle. This is the analysis that I was going to do is the one that your Lordship has made for himself. So 882 provides that so 8 sets out the provisions of this directive. This is what we're saying, that 8.2 sets out the provisions of this directive, the words that we've seen before in 5, in accordance with which under 5.1 it is appropriate such that NRAs must ensure adequate access. In other words, 5, first subparagraph, is talking about the SMP procedure under 8.16 of framework and the access and the conditions that may be imposed under 9 to 13. And that is the limitation of the general power, which is why it is necessary for the courts, for it then to say in particular, without prejudice to that I have just said, is the right reading, the first subparagraph, you can still do against non-SMP operators what you can't do against them under 12, because they would have to have SMP for that, to do it to them under 12. Read together with, my Lord, Article 8.3, to which we now come, and then the last paragraph of the first subparagraph of 8.3 is the one that your Lordship said, basically the prohibition against doing this to non-SMP operators. And then it goes on to say, and this is what I refer to as the last paragraph of 8.3, this is what creates, in exceptional circumstances, not whenever the regulator wants to do it under Article 5, in exceptional circumstances, when a national regulatory authority intends to impose on operators with significant market power obligations for access or interconnection other than those set out in Article 12, the one what we're concerned with, in other words, something other than what could have been done to it under Article 12, it shall submit this request to the Commission. The Commission shall take utmost account of the opinion of the body of BEREC, the body of European regulators for electronic communications, and the Commission, acting in accordance with Article 14.2, shall take a decision authorizing or preventing the national regulatory authority from taking such measures. And I say, my Lord, that means, and this is the mistake from which the Court of Appeal departed, that in the light of this to say that something which the Court of Appeal has agreed cannot be done under Article 12 to a GIB Telecom that it found had SMP in Market 4, which it thought was engaged, can nevertheless be done under Article 5, completely bypassing these provisions that say that they are, and because they would be additional measures, because they're not allowed to be done under Article 5. If the court had thought that what it ordered under Article 5 could have been done under Article 12, my learned friend Mr. Seeger, client, then represented by my learned friend Mr. McLean, would have won the Article 12 point down in the Supreme Court, not just the article, and would not have lost the Article 3. He would have won on both points, or rather, better still, he would have won on Article 12, and Article 5 would never have arisen for decision, or even for consideration by the court. So the court acknowledged by that decision that this was a measure that it couldn't apply under Article 8, under Article 8, through Article 8 under Article 12. Therefore, it is a measure. It is a measure that, other than those set out in Articles 9 to 13, other than those set out in Article 12, which are limited to networks and their associated facilities, Article 12, and the decision maker is in effect the Commission, not the NRA, not the GRA. And ergo, it can't be that Article 5 provides the general power in contradistinction to the more limited interpretation of which the GRA has now begun to contend, has always begun to contend, and which I hope to be able to demonstrate to your lordship is how it has been interpreted by others. So my lords, just to summarize very quickly, therefore what I'm saying in terms of the scope of the first part of 5.1 is that the words "in accordance with the directions" limits the first part of 5.1 to the SMP procedure and Article 8 and Articles 9 to 13. That is what Article 5 is about. I will see that Lord Sumption said that effectively in the list that he gave of the purposes for which I'll take your lordships to that in a moment. That is what triggers the obligations under Article 5, without prejudice to Article 5. Article 5 then says, without prejudice to anything I can do under Article 8.3. And therefore, what is carved out by the second part, beginning in particular of 5, from what I say is the correct interpretation of the first subparagraph, which is the full Monty regime created by the regulatory framework, namely 16, 8, and 12, what is carved out of that relates to what can be done to non-SMP operators, notwithstanding that it can't be done to them under Article 8 and 12. And the ways that when the court has had recourse in these 4 cases that I've just mentioned to your lordship, and are heavily relied on by my learned friend, when the courts have dealt with those cases and have invoked Article 5 and have said, by means not exhaustively set out there, they have nevertheless specified solely for interconnectivity. Completely unnecessary, if I'm wrong. Completely unnecessary, but absolutely necessary if I'm right. So, given the second paragraph, given the last paragraph of Article 8.3, I say that the GRA itself has no power under Article 8.3 to order additional measures And the second paragraph of the last paragraph of Article 5.3 says that the GRA mustn't, and that is effectively a decision by permission of the Commission. And therefore, it's not my power. I won't take up my Lordship's time with Article 12, but your Lordships will find it at page 610 of the electronic bundle. But just to complete the circle, and your Lordship is absolutely right, and I think this is why Lord Sumption says what he says when I come to it in a moment, that Article 8 actually creates an obligation on member states, not on NRAs. It creates an obligation on member states to provide power, and the conditions that may be imposed under Article 8, which does not create a power, is under Articles 9, 10, 11, 12, and 13, and we'll see what that led Lord Sumption and the House of Lords to say were the circumstances in which the powers could be used. It is true and right that I should say, my Lord, that when the Gibraltar legislature has transposed Articles 9, 10, 11, 12, and 13 by articles which always have one number more than by regulation, in the Gibraltar access regulations, by regulations 10, 11, 12, 13, and 14. Our regulation number is always one number higher than the article that it purports to transpose. They did give power to the NRA, to the GRA, it says may impose. Your Lordship can see that for themselves if they want to at page. So our access regulations are at page 873 of the bundle. And so, for example, taking your Lordships to Regulation 13 on page 866, which is what transposes Article 12, it says the authority may impose, which, in my submission, would bestow power. So, just to comment on Article 12, my Lord, there in the first paragraph, that it limits a national regulatory authority in accordance with the provisions of Article 8, impose obligations on operators to meet reasonable requests for access to and use of specific network elements and associated facilities. And that because it is limited to that, the Court of Appeal found in favor of the GRA's position and against my learned friend's client on the Article 12 entitlement to access. So then, my Lord, to bring all those bits together, this is what the GRA believes and submits to your Lordships is the proper interrelationship of Articles 4, 5, 8, and 12. Now, for the reasons that I've just explained, and my Lord, if I'll try to avoid repetition, because I've effectively, in answer to questions, referred to some of these points, so I'll try and leave them out of the account I give to your Lordships now of that argument. For the reasons that I have just touched on during my analysis of each of the 5 sections, articles, Article 5.1 provides a general power contrary to the statement in my written case that it provides no power. That's the first sub-paragraph. Contrary to the statement in my written case that the first sub-paragraph provides no power at all, which is a very bad, or rather a very bad articulation of a point, and therefore a bad point. Provides a general power, but one that must be exercised only where appropriate, to ensure, in accordance with the provisions of the directive, access and interconnection. And that means, in relation to access, by imposing access obligations under the SMP regime under Articles 8 and 12 on SMP operators found to have SMP in relevant markets. And therefore, insofar as concerns this, it is therefore necessarily limited, insofar as concerns this, namely access, as opposed to interconnection, because that flows from Article 4, not Article 8. Insofar as concerns access, it is therefore necessarily limited to operators with SMP. I should say, my Lord, just for the sake of completeness, that Article 4 interconnection is not limited to operators with SMP. Any operator, with or without SMP under Article 4, has the obligation to negotiate. And the obligation to negotiate has been found by the European courts not to include the obligation to conclude the negotiation. The first subparagraph of Article 5 does not of itself provide a power to impose any access obligation on non-SMP operators. It does not, because in accordance with this directive, where appropriate in accordance with the directive, is a road sign that points only at Article 16 of the Framework Directive, SMP procedure, Article 8 of the directive, and what it can do under Article 8, Articles 9 to 13, we are concerned with Article 12. That is the road sign. So that is the meaning of the words in accordance with this directive, takes you to that in respect of access. This position is then tempered by the second subparagraph of Article 8, which provides that, as we've said, the in particular, etc., etc. In particular, A, B, and C. And I've taken your lordship through effectively that to make any sense of them, the words that follow the words in particular without prejudice, and the words that follow without prejudice used there in Article 5 only make sense if they're read as if the word only were added, which is the way the courts, I think, have read it by using words such as solely, which are measures that could have been imposed on SMP operators under Article 12, and they are then caught in respect of A, B, and C by Article 12, not by this, leaving the second subparagraph of Article 5, A, B, and B, sorry, not C, to bite on non-SMP operators. Because it is, as we'll see in a moment, and as the Commission has said, Article 5 in this respect is an exception to 8.3. And it's an exception limited, because the words without prejudice to come after in particular, to the three cited examples no longer. That Article 5 operates as an exception to the principles enshrined in Article 8. Sorry, did I say I may have said as an exception to the principles in Article 8. 3, I meant Article 8, not just 8.3, my lord. I beg your pardon, I may have misspoken there. That is correct, namely that it is an exception, that 5 is an exception to 8, and not something that stands next to it in all its independent freestanding glory, is noted by the Commission in its uncriticized submission in this respect to the court in the Poland case at paragraph 51, which your lordship will see at page 955 of the bundle, in which the Commission said, and I quote, Article 5.1, this is a submission by the Commission, this is not a finding by the court, but this is, the Commission is the custodian under the EU treaties of the body of European law, generates directives, interprets them, and infracts member states for breaching them. I think they can be safely assumed that until a court of law says that they've got it wrong, that they are less esoteric than I am about, less in the esoteric class than I am in respect of these matters. They say Article 5.1 is not a mere programmatic provision, but a provision indicating the decisions which national regulatory authorities must be empowered to take. It is an exception to the general principles enshrined in Article 8 of the Access Directive, which must be interpreted restrictively. The effect of what I have said is that only A, B, and B are capable of being applied to non-SMP operators despite Article 8, i.e. despite the fact that under the SMP procedure it can't be imposed on them, is the exception. The exception is that notwithstanding that under Article 8, these things can only be done to operators with SMP, because of the without prejudice to Article 5.1 in Article 8.3, it can nevertheless be done to operators without SMP. What can notwithstanding that be done to operators without SMP? A, B, and B. List which is now much longer. And that is, in a nutshell, my lords, the position. And if I can ask your lordships to turn up the Telia Sonara case, which was decided on this very basis that I am describing to your lordship. So if I could ask your lordships to turn to the electronic bundle at page 1037. I beg your pardon? My learned friend is quite right. The report starts at 1030. Is that right, or am I wrong even on that? 1067. 1037 it starts. And I'll take your lordships more particularly to the pages. So that's where the report starts. At paragraph 57, and if your lordship could turn to 1063, because I will be going forward mainly from there. So if your lordship could press your buttons, I'm working from hard copies, but 1063. The first thing that the court decided at paragraph 57 is what I said to your lordships earlier, that basically this is the SMS case, right? That basically the requesting party requested under Article 4.1 interconnection for the purposes of allowing its clients to transmit SMS and messages of that sort to and MMS messages to subscribers on Telesonara's network. And the court found in paragraph 57 that it couldn't, because it wasn't itself, the requesting party was not itself a network operator. It was an electronic service provider only. And having said that it couldn't therefore allow the access, the interconnection is a form of access. Your lordships will have seen that perhaps already. And I think it's common ground between us all that interconnection is simply a form of access. It doesn't have it's not something different. It's a form of access. The court said, no, I can't give you that interconnection type of access under 4.1 because you are not a network operator. You're only a service provider. And then the court went on in paragraphs 58 to 59 to say, . points to little a in the list in the second subparagraph of 5.1. So at paragraph 58, am I right here? 59. In that context, well, first of all, it said in the previous paragraph 58, it repeats this mantra, by means not exhaustively listed there, by reference to Article 5. Your Lordships can see that. And then it says, in that context, in accordance with the point at A of the second paragraph of Article 5.1, those authorities must be able to impose, and remember, little a is about interconnection, access to end users, etc. In that context, in accordance with point A of the second subparagraph of Article 5.1, those authorities must be able to impose obligations on undertakings that control access to end users, including in justified cases the obligation to interconnect their networks solely in order to ensure end-to-end connectivity. Solely in order to ensure end-to-end connectivity. In other words, only for the purpose, not limited to the means for achieving that purpose, but only in little a, but only for the purpose of A, which is to ensure access to end users. The court needn't have said solely if it thought that it was proceeding under a much wider power under the first paragraph of 5.1. The court then says at paragraph 61, which is on the same page, that thus it is apparent that the relevant provisions of the Framework Directive and the Access Directive enable a national regulatory authority to take a decision ordering an undertaking which does not have significant market power, not regardless of whether it has significant market power, it has significant market power, but which controls access to end users. In other words, if they can fit in little a of the second subparagraph, to negotiate either an interconnection of the two networks, etc., etc. In other words, my lord, the NRA has power to impose a condition under 5 on non-SMP operators, and despite them having there being no identified market and they not having SMP in it, only because it falls in the list of exceptions in Article 5, i.e. cases in A, AB, which I told your lordships earlier had been added later. AB did not exist at the time of Telesonaria and was put there because of Telesonaria to make separate from A. So the court in Telesonaria had made it fit under A, and the European Commission thought, we agree with you, but we want to make separate provision for A. Yeah, and that's how AB was born. Also, they say at paragraph 62, at the bottom of that page, EB 1064, it follows from the foregoing that the answer to the third part of the first question referred is that a national regulatory authority may require an undertaking which does not have significant market power, but which controls access to end users to negotiate in good faith with another undertaking. And that reference to negotiate in good faith is because they were using this powers in the context of 4.1, which doesn't create an obligation to actually conclude an agreement. It simply includes an obligation to negotiate in good faith. And there, I've mentioned already, your lordship, to the solely point. And of course, the solely point validates the GRA's analysis, because if the Court of Appeal and the respondent are correct, the solely stricture would be completely unnecessary, and there wouldn't be any need for any such imperative that it should be done solely for that purpose. Accordingly, the GRA concludes that power in 5.1 is limited to the 3 cases then in the second subparagraph of A, which, as I keep on saying, EECC has listed. And saying that the EECC has expanded the list, my lord, is not an entirely irrelevant point. Because if the point was a general one, applicable to everybody, including SMP operators in respect of things that could also be done to them under Article 12, why would the legislature feel the need to broaden the list? They must be wanting to broaden things that can be done to somebody whom it can't otherwise be done to. It can't be to allow to be done to people things which can also be done to them under some other provision. So, my Lord, other validation of that position beyond this telesonaria case that followed that very thinking and articulated its decision in accordance with how the GRA interpreted the position are the following. My Lord, what the UK House of Lords has said about this, and if your Lordship could turn up, the case itself starts at page 907. This is British Telecom versus Telefonica. That's a case that went to the House of Lords. It was about whether BT was entitled to increase the cost of, I think it was transferring calls to non-geographic numbers in a way that other operators complained made it so expensive that it amounted to an obstacle to access to the end users connected to GibTel's network. So that's the background of the case. But at paragraph 11, and in that case, before paragraph 11, Lord Sumption, with whom the whole of the five-man Court of Appeal agreed, provides a little précis of what the Common Regulatory Framework is about. It's one of the sources that you ought to take that from. Paragraph 11 then says, reserve powers, paragraph 11 at page 914 of our bundle. Reserve powers are required to be conferred on national regulatory authorities by Article 5. By the way, my learned friend, Mr. Segan, your Lordship, say that he has no difficulty with the description of this as a reserve power. Reserve powers are required to be conferred on national regulatory authorities by Article 5 of the Access Directive to impose what we've seen, this objective, transparent, proportional, and non-discriminatory terms calculated to achieve the objectives in Article 8. In summary, these powers are exercisable where it is necessary to do so in order, 1, to achieve end-to-end connectivity in a case where the parties have failed to agree interconnection terms, Article 5.1 and 5.4 of the Directive. Teleasonara. In other words, everything that fits into little a, which the means of which are not exhaustively listed there, and therefore can be by ordering this or ordering that. Those are the unexhaustively listed means, provided that the objective, which is exhaustively listed, is to achieve end-to-end connectivity. And all, as I say, all the cases were end-to-end connectivity cases that weren't established. We have been able to find no case, my Lord, that is outside the realms of my analysis. That is to say, that relies on Article 5, first subparagraph, for a reason, for a purpose, that is not also captured by little a of the second subparagraph. Secondly, he says, or, this is the summary of what Lord Sumption and the House of Lords thought were the, I beg your pardon, not the House of Lords, my Lord, the Supreme Court, I do beg your pardon. The second one is, or to achieve the objectives in Article 8 of the Framework Directive, in a case where interconnection terms have been agreed, but not calculated to achieve those objectives. Not interconnection whenever it serves the regulatory objective, regardless of whether you got SMP or not this general freestanding power interpretation. So 5, so that's basically that, and then 3, or in order to impose certain kinds of terms on parties with significant market power, Articles 8 to 13 of the Access Directive. In other words, in accordance with this directive, which includes Article 8, pursuant to which, but no power to do which, is included in Article 8 under Article 12, the Article 12 conditions. And then he goes on to say, it should be noted that the promotion of efficient and competitive markets is one of the overarching objectives in Article 8.2 of the Framework Directive and is therefore potentially relevant to all three cases. He doesn't say you can do whatever you want under Article 5, sub-paragraph 1, because of the overarching condition. He says that it might be relevant to any of the three. In other words, the regulatory objective informs and guides the NRA in whether, when, and how it exercises the powers in A, B, and B. It doesn't drive when those powers exist, which is my learned friend's case. He says that provided it's to achieve the regulatory objective, first subparagraph of Article 5 is a general Pandora's box for regulators to do what they like when they like. And this was not a fact-specific assessment by the court. The court was not concerned with the things that it is. It was concerned with wanting to give access through one particular means interconnection, but it was under Article 13. So this was about price controls. I said at the beginning that Article 12 is the one that we're concerned with, relates to access to networks and associated facilities. In this case, it was under Article 13, price controls and price control matters to lift the insidious consequences of an abuse of dominance by an S&P players. But the assessment that Lord Sumption and the House of Lords adopts, that the Supreme Court adopts, is in no way specific. And of course, we've all resorted to saying that it's fact sensitive, and we can't find any other way to avoid, to slip out from under the consequences of an authority. But on no reading, what Lord Sumption did was first of all give a general description of the whole of the common regulatory framework. And in the context of that general description, he said what he thought Article 5 was about and for, and what its scope was. And these coincide precisely with what I am submitting to your Lordship is the GRA's understanding of the correct interpretation of the scope of Article 5 as read with Article 8 and as read on one side and as read with Article 4 on the other. I've already taken your Lordship to the Telesonaria European Court case, which also adopts the same approach. And then I'd like to turn your Lordship now to these community guidelines. If your Lordships could turn to, it starts at page 208, and I'd just like your Lordship to go to that page so that you could see the title of this document. So these are Commission guidelines on market analysis and the assessment of significant market power under the Community Regulatory Framework for Electronic Communications Network and Services. And I'd like to take your Lordships forward now to page 222 in your Lordship's electronic bundle. And now what the Commission has done in this document, and I'm not going to take the board's time to look at it, is describe all the business about the framework and the objectives and the framework process and all of that, and says, under the heading 4, on the right hand, halfway down the right hand column on that page 222, imposition, maintenance, and amendments, or withdrawal of obligations under the regulatory framework. And then it says about 6 lines down in paragraph 107, this section aims to provide guidance for NRAs on the actions they should take following that analysis, i.e. the imposition, maintenance, amendment, or withdrawal as appropriate of specific regulatory obligations on undertakings designated as having SMP. This section, these are the words I want, the next 4 lines are the ones I want your lordships to have particular regard to. This section also describes the circumstances in which similar obligations on those that can be imposed on SMP operators may exceptionally be imposed on undertakings who have not been designated as having SMP. And then they go on 111 SMP, and then they go on 112 to set out the SMP procedure. We've covered that ground. Simply to point out at 116, in case your lordship want to see it there again, confirmed by the Commission, at paragraph 116, 5 lines down, NRAs will have to choose between the range of regulatory objectives in order to remedy a particular remedy, blah, blah, blah. I beg your pardon. To remedy a particular problem in a market found not to be effectively competitive, where NRAs intend to impose other obligations for access and interconnection of those listed in the Access Directive, they must submit a request for the Commission approval of their proposed course of action. The Commission must seek the advice of the Communications Committee, that's BEREC now, before taking its decision, i.e. the last paragraph of Article 8.3 that we've been speaking about. And going forward over the page to 224, so all of that was under the heading of what they could do to SMP operators. And then 4.3 is headed imposition of certain specific regulatory obligations on non-SMP operators. Well, the certain and specific would be pretty unusual words to describe the interpretation of Article 5 for which others contend. And it says, the preceding parts of this section set out the procedures whereby certain specific obligations may be imposed on SMP undertakings under Article 7 and 8 of the Access Directive and Article 16 of the Universal Services Directive. Exceptionally, similar obligations may be imposed on operators other than those that have been designated as having SMP in the following cases listed in Article 8.3 of the Access Directive. And that is in 8.3, the without prejudice to list, which starts with Article 5.1 and Article 6 that we have seen. And it says, it doesn't say anything that can be done under 5.1, it lists the description of the objectives. It lists the description. Obligations covering inter alia. The Court of Appeal ruled against me on this submission on the basis of the word inter alia and rejected the proper interpretation of the use of the word inter alia there, which I will come to in just 45 seconds. Inter alia, access to conditional access systems, which, by the way, my lords, is Article 6 of the Access Directives, and then, comma, obligations to interconnect to ensure end-to-end interoperability, which is a very abbreviated version of little a in the second subparagraph of 5.1. And then it says access to application, programs, interfaces, electronic program in relation to digital TV, etc., which is B of the little list, an abbreviated version of B in the little list. So they don't say here the first item on this list is not some general whatever 5.1 permits. It is an abbreviated articulation of what the Commission thinks is the effect of that 5.1 exception, which we know is an exception to H3. And the reason why it uses the word inter alia is not because other things are permitted. It's not because the list of what is permitted after in particular is longer. It's longer as to means, because the means are not exhaustively set out there. But it's not longer as to the purposes for which those means must be deployed. And the reason why they say inter alia is not because that is wrong, it's because their description of A and B, and for that matter, their first item, which is Article 6, with which we're not concerned, my lords, is not exhaustive. In other words, it's not a complete iteration of what B, not AB wasn't there at the time that this document was created in 2002. A and B and Article 6, which is the first indent of without prejudice in 8.3, Article 5.1 and Article 6. Because this list is too short and is only headline descriptions of what those paragraphs permit, it says inter alia. Because if inter alia means not what I am submitting, but that it's anything and everything, then first of all, there was no need to waste these 6 lines in abbreviating any part of the description. And secondly, it would drive the coach and horses that I described earlier in my submissions. So, my lords,
isn't the inter alia only part of the Article 6 summary?
My lord, it is as consistent. That is as consistent with what I've said. It could be applied to that, but if it applied to that, it would apply to the other items on the list for the same reason, that the items are shorthand. All of the items are shorthand, not just Article 6.
Well, I haven't studied Article 6, but maybe it goes a bit broader than access to conditional access systems in some circumstances.
Well, my lord, it's possible, and that would strengthen my position even further, because it would mean that the other items are not subject to inter alia. The Commission purports to be describing the entire scope of the Article 5.1 exception from the principle in Article 8, which is what we're saying, which is our argument. Which is our argument. We're just getting there, my lord, by different routes. I beg your pardon? Oh. Yes, thank you. So I'm very advanced. Nor would these be exceptions, nor would it otherwise be defined cases or certain cases or indeed exceptional cases. My lord, and the same view is taken by the reference book writers. There's no point, as my learned friend does, picking out isolated sentences that speak of general powers and taking them out of the context of the whole regime. So if, for example, at page 1343, Garziniti, speaking now of the 3rd edition, I'll come to the 4th edition in a moment. So Garziniti and Niehood are the 2 leading telecommunications, European law telecommunications textbooks, reference works. And at paragraph 1-051, which is at page 1343 of your Lordship's electronic bundle, he says the imposition of an access obligation on passive network elements falls only within the scope of Article 12, not within the Article 12 mandatorily, but Article 5 permissively, falls only within the scope of Article 12 of the Access Directive. And to impose such an obligation, an NRA must first designate the undertaking concerned as having significant market power on the relevant market. Only within the scope of Article 12 excludes it from the scope of Article 5. And then, my Lord, I don't know if your Lordships are willing to allow me to refer them briefly to other pages of Goszinity that I belatedly added to the electronic bundle. Your Lordships will find them at page 1391. The answer is no? They weren't added. Sorry? You have them anyway. But, my Lord, they haven't been added to the electronic bundle, but I'm told by one of my colleagues here that your Lordships have them anyway.
Have an additional bundle with extracts from the third edition of Goszinity, but I think that's what you were referring us to a moment ago.
Does it begin, my Lord, with...
It begins with paragraph 1-234.
Yes, is that the one? Yes. My Lord, that's the one that I'd like to refer to. Is that, can you just check on our page 139? I beg your Lordship's pardon. Can you check on our, I just don't want to mislead.
Because we have it as a separate bundle, we have it as pages 1-8.
All right, my Lord, those are the right pages. Those are the pages in question. So my page reference numbers, so Philip, I'm going to rely on you to provide me with the...
If you give us the paragraph numbers, we'll soon find the where you want us to look.
Yes, my Lords, what I am going to do is what is the paragraph number, Philip? I've got it. Sorry? 1. Right. I just want to make sure, my Lord, that I don't stray into... Yeah.
Oh, and we also have, yes, we have a number of bundles. But I think
it's there at 1236, at paragraph 1236 of Goszinity.
Yep.
Under the heading, general obligations applying to operators regardless of their market power. So now, what can be done to people even though they don't have market power, significant market power? Your Lordship would expect to find there a very brief paragraph saying words to the effect of my learned friend is contending general, it doesn't matter, it's prohibited by Article 8.3, you don't have to have SMP, but it can also be done to SMP, and the general thing for which they contend that provided it achieves the regulatory objective of competition and they follow the right procedure under 5, the sky's the limit with 5. No. What the text writer then does over the next page is list the general obligations applying to operators regardless of their market conditions. So the first one is obligations to negotiate interconnection. Under Article 4, I've already taken your Lordship through that. The next one over the page at 1-237 is end-to-end connectivity and interoperability, little a. Then, turning the page forward at paragraph 1-238, he goes to other obligations for improving competition. Well, here surely you must find, given my learned friend's submission, here you must find the all things to all men scope, but no, it's listed to specific items that under specific provisions of the regulatory framework, it is permitted to be done to non-SMP operators. And then at 1-239, co-location and sharing of associated facilities. And under 1-240, things to do with accounting separation or structural separation of networks. And then at 1-241, conditional access systems and other facilities for broadcasters. And then At 1242, complying with your international commitments, is also on the Commission's list and in the guidelines that I've just been reading from. And there it ends. So this textbook writer, in writing the chapter about things that can be done to non-SMP operator, gives no hint of me being wrong and my learned friend being right and the Court of Appeal being right. The opposite is true, consistently with what Lord Sumption's view and the Commission's view. And then he moves straight on to obligations which may be imposed upon undertakings with SMP. And the rest follows. We know all about that. That is the SMP with the SMP regime. So I say that also demonstrates that there is no freestanding, wide-ranging power as contended for by the respondent to impose under Article 5 on non-SMP operators, still less under SMP operators, given the strictures in the last paragraph in Article 8.4, any of these additional things that are either not in Article 12 in the case of SMP operators, and not in A, B, and B of 5 in the case of non-SMP operators. And this has not changed because of the EEEC, and Mr. Garzaniti, although I don't think he's the editor anymore, he may be, but the editors of this book haven't had a change of heart, as my learned friend appears to insinuate in some parts of his written case. All he says at paragraph 2-130, which I hope is the next page on your Lordship's little bundle, perhaps it's not.
Just a moment. No, we only
this could be main. This is in the electronic bundle, my lord. Oh. If your Lordship could turn to page 1350, it's in the electronic bundle because I think my learned friend put it there. At page 1350. So at paragraph 2-130, which is the paragraph on which my learned friend Mr. Segan relies, the powers are very broad, and indeed they are very broad. But very broad doesn't mean unlimited, and indeed the description of them as very broad imputes the sense that they are not unlimited. So if there is an omnibus power, to say that it is very broad is to acknowledge some limitation to them. Otherwise, you would just say it's an omnibus power to pursue any of my regulatory objectives. And whether it's broad, narrow, or somewhere in between is an irrelevant characterization, an inapplicable characterization of them. And what he refers to, and they are broad because they are indeed broad, which is all that Mr. Garzaniti says in that paragraph in the 4th edition. That's the 4th edition now. The one that was that reflects the EECC, which we all agree does not change the law, is relevant to us in this case. It allows all end-to-end connectivity and interconnection stuff that we have seen in the cases, by means that are not exhaustively listed there. That's broad. It allows all Article 6 conditional access decisions, that's broad, and Articles 8 to 13 issues in relation to SMP operators, which are broad. And that is Lord Sumption's summary of them. And the final thing that I'd like to put to your Lordships, to demonstrate that the GRA's interpretation has merit, is the UK's own transposition of its obligations under Article 5. Right, there's no point my learned friend saying, as he does, that your lordship mustn't read anything into that, because Gibraltar is Gibraltar, the UK is the UK, and how the UK has done it has nothing to do with what the law is in Gibraltar. Gibraltar is not a separate member state. The established jurisprudence of the European Court of Justice, and indeed of the UK courts, is that Gibraltar is part of the member state UK, which is why, despite voting by 99% to remain, we are exited. And the member state that is infracted if Gibraltar mistransposes its obligations is not Gibraltar, it's the United Kingdom. And neither Gibraltar nor the United Kingdom, unlike Poland, have ever been infracted for mistransposing Article 5. And the UK provisions for transposing its Article 5 obligations, in other words, ensuring that the regulator, that Ofcom, has the power to do all the things that are said to be required by Article 5, or permitted even by Article 5, would clearly not be permitted and are not reflected in the UK's transposition. So, my lord, I'd like quickly to refer your lordships to.
Sir Peter, rather, I think we'll better leave that until after the adjournment.
Okay, my lord, I'm sorry, I didn't realize I had overrun the time for this morning's session already. I'm grateful to your lordship for that degree of latitude.
Not at all. We'll resume at 1 o'clock, I beg your pardon, at 2 o'clock our time. And in the meantime, we'll adjourn.
Obliged.